Is the screen clearly visible?
Yes, sir.
Okay. So in the last class we have discussed till here. Okay. So regarding different aspects related to the constitution, and we have discussed relating different aspect related to the Parliament of India. Okay. Now we'll discuss certain current affairs related to center-state relations. Okay. Many times this is one of the favorite subject of the UPSC. Okay. So the first topic is interstate river disputes. It's been in use since independence. Okay. There is one or another kind of dispute since independence. Okay. After the formation of different states and after state reorganization, there were many disputes, okay, between the sharing of waters between two states. Okay, if you see here, there are the major interstate river disputes are given in this particular map. If you see here, there is three rivers are there: Ravi, Bias, and Satluj. Okay, Ravi, Bias, and Satluj. These rivers pass through these particular states: Punjab, Haryana, and Rajasthan. So there is a dispute between sharing of that waters of those particular rivers. And Narmada, okay, between the Madhya Pradesh, Gujarat, Maharashtra, and Rajasthan. Okay, Mandovi or Mahadayi river is there. The Goa, Karnataka, and Maharashtra region. Here one river will be there. Okay, Mandovi, Mahadayi river. And the Krishna river is a famous one between Maharashtra, Andhra Pradesh, Karnataka, and Telangana. Between Telangana and Andhra Pradesh is one of the, since 2014, after the formation of Telangana state, it is one of the major concern between the two particular states. Okay, and Periyar river is there between Tamil Nadu and Kerala. This Periyar river. Okay, Krishna river is there. Narmada river is there. Okay, Mahadayi river is not given in the map. And then if we see Kaveri dispute has resulted in many violent acts also. Okay, between the Karnataka, Tamil Nadu, Kerala, and Puducherry. Between Karnataka and Tamil Nadu is one of the major bone of contention. And Godavari dispute is between Maharashtra, Andhra Pradesh, Telangana, Karnataka, Odisha, Madhya Pradesh. And Vamsadhara river is between Andhra Pradesh and Odisha. So these are the major disputes. So if you can see, there is a pattern in these particular rivers. Okay, except Indus rivers, all these are perennial rivers. All these are the rivers in the peninsular India. Okay, these are annual rivers. Sorry, not the perennial rivers. These are annual rivers. These are seasonal rivers. Means in the one particular season, in the monsoon season, they will be overflowing, and in the dry season, the summer season, there will be less amount of water. But if we see other rivers such as Ganga, Yamuna is there, Brahmaputra is there, and Indus is also there. Those particular rivers are perennial rivers. They are continuously flowing because the origin is Himalaya, the great Himalayan glaciers. So there will be continuous melting of this water, and that particular water comes to these particular states. But if we see the rivers in the peninsular plateau, this area, these rivers are dependent upon monsoon. Okay, monsoonal. So when there is heavy rains, then there will be formation of this rivers. So there will be constant dispute in these particular rivers. Okay, so you have to see in which particular rivers there is a dispute, and also one more aspect is there. Okay, we'll cover later on. That is linking of this particular river. There is a plan. Okay, huge plan by the government. Okay, KN Betwa link project is there. Okay, that's proposed in this particular budget. Except that there is a plan to link these perennial rivers. Okay, Ganga, Brahmaputra perennial rivers with the annual rivers of peninsular India. Okay, there excessive water flow is there. Here a deficient water flow is there. So if we can link those particular rivers, there will be sufficient water distribution across the India. It is also having certain number of disadvantages, but it's a plan. Okay, so if you see the interstate river disputes, okay, recently what happened in the news, Ministry of Jal Shakti has notified jurisdiction of the Godavari River Management Board and Krishna River Management Board and Andhra Pradesh under the Andhra Pradesh Reorganization Act of 2014. So there is a dispute between Andhra Pradesh and Telangana, right? So Ministry of Jal Shakti has notified the jurisdiction, enhanced the jurisdiction of this Godavari and Krishna River Management Boards. Okay. So if we see, there are certain constitutional provisions for the interstate river water disputes. How to solve this interstate river water disputes? Okay, states have certain autonomous powers. Center cannot simply enforce all its rules and regulations over the states. States needs to come up with its own rules. And in the seventh schedule, okay, which divides the powers between the center, state, and the concurrent list, in the seventh schedule, entry 17 of the state list, remember this, entry 17 of the state list deals with the water supply, irrigation, canal, drainage, embankments, and water storage and water power. All these aspects are in the state list, means state government. Okay, state legislature has exclusive rights to make laws for anything related to water, remember. But entry 56 of the union list gives the powers to the union government for the regulation and development of interstate rivers and river valleys. So if you can see, only certain number of small rivers are there that belong to only one state. Rest of the major rivers are between the states. Those are called interstate rivers. Okay, for the regulation and development of these interstate rivers, major rivers, big rivers, whatever rivers are there, those rivers, that control is under the union list. Okay, so there is one article, article 262 of the constitution. Okay, it provides for the adjudication of disputes or complaints related to the water and interstate rivers and river valleys. Just after independence in 1956, what happened? These kind of disputes started emerging, and there is a constitutional amendment and introduction of this particular article, article 262, for adjudication of these disputes. Okay, and Parliament by law provides that neither Supreme Court or any other court to exercise the jurisdiction in respect to the such dispute or complaint. So what happens when there is a dispute between the states or between center and the state? What will happen? They will go to the Supreme Court. Okay, so they cannot go to the High Court, because which High Court they will go? If there is two states, two High Courts are there, no? So High Courts they cannot go. Supreme Court is also not having any powers to see and to give judgments related to this sharing of the water. Okay, so and Parliament has enacted for that. Then who will take care, who will solve these particular disputes? There are the Parliament enacted two laws. Okay, one is River Boards Act, which provides for establishment of river boards. These particular river boards are present for every river for the regulation and development of interstate rivers and river valleys. For every river, particular river board is there. Okay, for example, here in the news, Krishna River Management Board is there, Godavari River Management Board is there. Like that, river boards are there, constituted under this particular law, that is River Boards Act. Okay, they are established by the central government on the request of the concerned states. And there is Interstate Water Disputes Act of 1956, which empowers the central government to set up a tribunal. What is a tribunal? Tribunal is a quasi-judicial body. It is not like a court or executive authority. It is between court and executive authority, quasi-judicial body for adjudication of interstate river disputes. The decision of the tribunal is final and binding. Remember, final and binding. There is no appeal. Whatever tribunal says, the state should comply on that. Okay, in this way, the disputes are solved by Interstate Water Disputes Tribunal. Okay, so what is the problem with this particular tribunal? It is not a permanent body. Okay, for every dispute, if it is arising, for example, Kaveri River dispute, if it is arising, then state governments will request the central government to set up a tribunal. Then the tribunal will be set up, and it will take certain amount of time in order to give a judgment. In some cases, it may take up to 10 or 20 years to give a judgment. Setting of the tribunal, and then the tribunal will see whatever, try to negotiate between the states. Okay, the states will not simply accept that. So it is a time-taking process. Okay, so who is the chairman and the members of the water dispute tribunals are nominated by Chief Justice of India. Sir, here it is said that Supreme Court has no jurisdiction, but Supreme Court has power to nominate the chairman and members of the water dispute tribunal. Okay, remember this particular point. And recently there is an amendment, that is Interstate River Water Disputes Amendment Bill. Okay, it is passed by the Lok Sabha and seeks to replace the dispute settlement mechanism. So whatever dispute settlement mechanism is there to set up the dispute resolution tribunals are there now. So in order to amend that particular provision, okay, this act is trying to set up a permanent dispute resolution committee and a single permanent tribunal. Okay, dispute resolution committees and a single permanent tribunal for dispute settlement for all the rivers of the all the states. Okay, if there is a dispute or not, there will be a permanent dispute settlement tribunal will be there. Okay, whenever there is arises a dispute, the states can directly go there. Okay, it will reduce the amount of time, okay, in order to set up the tribunal and set up its chairman and all. Okay, so it will cut short the amount of time required. So what do you have to remember? You have to remember that entry 17 of the state list relates with water, entry 56 interstate river valleys, article 262, okay, you have to remember, and River Boards Act 1956 and Interstate Water Disputes Acts you have to remember. Okay, chairman is appointed by the Chief Justice and there is a new amendment, okay, a new dispute settlement mechanism to set up a single permanent tribunal. Remember that point. Okay, so you just go through this particular map and just see which of the following rivers are under dispute and what are the states that are present that are having this particular dispute. Okay, so there is the next concept, interstate border disputes. Okay, so we have seen just river disputes, there is also border disputes also. Okay, recently Assam and Meghalaya government has agreed to settle the long pending interstate border disputes in 6 areas. So in 6 areas there is a dispute. Just a minute, someone join. In 6 areas there is a dispute, okay, between Assam and Meghalaya. This is Meghalaya and this is Assam in 6 areas. So that's in the news. And you know the history that Meghalaya was carved out of Assam and became a full-fledged state in 1972. Okay, 1972 Meghalaya became an autonomous state, independent state. Okay, there is this area, this border is 884 kilometers long border with 12 points of dispute between the states, and 6 areas the dispute have been going to be settled, okay, amicably between the 2 states. So if you see what are those particular area, okay, Langpi, Boko is there, okay, Kamrup and Kamrup metropolitan area is there, Alicandi district is there. Just have a glance, but you need not remember the names of these particular places, but just remember there is a dispute between Assam and Meghalaya. Okay, so this dispute stems from the Meghalaya government refusal to accept the Assam Reorganization Act. Okay, there is an Assam Reorganization Act passed in 1969. Okay, it just try to modify the areas that are present, that are given to the Assam from Meghalaya, and the population wise census dependent. It's a census dependent exercise. It was done, but the Meghalaya government did not accept this proposal. So in 6 areas, now there will be an amicable solution between these particular states. So if we see, there are numerous disputes, okay, border disputes between different states. So you just have to have an idea. So here these green color lines, vertical lines are given, those are active border disputes, okay, but these black color lines are there, no, those are dormant ones, means currently not active. So if we see what are the disputes, there is a dispute between Haryana and Punjab. Okay, it's a long pending disputes for the Chhattisgarh area. Okay, and Himachal Pradesh Ladakh area is there, between Himachal Pradesh and Ladakh, and Haryana Himachal Pradesh, okay, Gujarat Rajasthan, and then Odisha West Bengal, okay, and then Maharashtra Karnataka and Karnataka Kerala. So these areas are having dispute. Presently Assam Meghalaya is also having a dispute. Just go through this particular map, okay. So identify which of the following states have the active disputes presently going on and what are those particular areas. For example, active dispute is there between Himachal Pradesh and Ladakh, okay, over Sarchu area, that is lying along Leh Manali highway. Okay, there is a Leh Manali highway. Okay, so over this particular Sarchu area, and active dispute between Haryana and Himachal Pradesh, okay, over Parwano region in Panchkula, and then Gujarat Rajasthan, it's a dormant dispute. Odisha Bengal also dormant dispute. But Maharashtra Karnataka, it's an active dispute over Belgaum district with large Marathi speaking population. Okay, the border area, there is a Belgaum district. Okay, there is a large Marathi speaking population and it was part of Bombay Presidency under the coming of Karnataka. So Karnataka formed in 1956 and this Belgaum district went to Karnataka. So that's a dispute. Okay, so just identify these areas. Next. So how to resolve these particular disputes? The central government came up with a decision to form this particular special regional committees by states to resolve this particular issue. Okay, special regional committees. So if you see the Indian administrative division and its interstate border disputes, okay, it is one of the India, if you see, throughout the history, it is one of the oldest and greatest civilization of the world, and the present day Indian Union was formed by joining 550 princely states. 550 princely states. Okay, that many number of independent kingdoms are there and British territories. Okay, they were integrated into now 28 states and 8 union territories. It is a really difficult task. Okay, and the State Reorganization Commission in 1953 divided this Indian territory into 14 states and 6 union territories. Today after subsequent reorganizations, the total number of divisions was 28 states and 8 union territories. But there are certain border disputes till now. Okay, still active. So how they can be resolved? By setting up special regional committees. Okay, and the state governments together can amicably solve these particular disputes. Okay, so you may get a doubt, sir, who will be what authority, like which authority has the power to alter the boundaries of a state or alter the name of that particular state? Only central government. Okay, not central government in particular, parliament, that is Lok Sabha and Rajya Sabha. Parliament has the power to change the borders, reorganize the state. State government cannot do that. Okay, state legislature cannot do that. Only parliament has the power to do that. But changing the name of a district, okay, with the approval of certain ministries of the central government, the state government through an executive order or a law, they can change the name of a district. But changing the name of a state, that also requires parliamentary approval. It can only be introduced in Rajya Sabha, and after passes by the Rajya Sabha, it goes to the Lok Sabha. Okay, but states, just opinion is sought by the president. Before putting that bill into the parliament, president will ask for state's opinion. If the state governments accept that particular proposal, okay, it will pass to the it will go to the Rajya Sabha and Lok Sabha, and it will get passed. Okay, if the state governments reject that proposal, still president felt that it should be done, then without state's opinion, irrespective of the state's opinion, the parliament can take action. Okay, so that is about the dispute between the state boundaries. Next is about 7th schedule, very important. 7th schedule, many times question is asked. So if you see 7th schedule, why it is in news? Okay, 15th Finance Commission chairman said that, okay, there should be a review of this particular 7th schedule of the constitution in the wake of current challenges of climate change and pandemic. Okay, so there is climate change, there is pandemic, and new and emerging problems are there. Okay, so to solve those particular problems, it is not clear whether the state government or the central government or it is a concurrent subject. There is no clarity. That's why there should be a review of the 7th commission. 7th schedule ordered by the 15th Finance Commission. Okay, so what is this particular 7th schedule? If you see under Article 246 of the Constitution, there is a legislative power on the Parliament and state legislature on the subject enumerated in the 7th schedule. Okay, so there is Lok Sabha plus Rajya Sabha. Okay, the state government, state legislature will be there. Okay, so on what subject Lok Sabha and Rajya Sabha has power to pass a law, and what subject state governments has to pass a law, that is mentioned in the 7th schedule. And in certain subjects, both parliament and state legislature can pass law, that is concurrent list. Okay, if you see, there are three lists. List 1 is the union list. Parliament has exclusive power. No state government can pass law. For example, defense of India, foreign affairs, railways, banking. Okay, central government financial institutions. Okay, so different aspects, external affairs. So these aspects are there, no? Only Parliament can make laws. There are 100 such items. Okay, so just give me a minute. There is someone came. Just a minute, I'll come back. Sorry for the delay. So we are saying the union list or the central list has these particular subjects 100 in number. Originally there are 97, but after subsequent amendments of the constitution, now 100 number items are there. Okay, so list 2 deals with state list. Okay, in which state legislature assembly and state legislative council in particular states has exclusive jurisdiction over them. For example, police and public order, public health and sanitation, betting and gambling, agriculture. Okay, these are under state power. Only state can do that, and 61 in number. 61 items state can pass a law. Concurrent list, over which both parliament and state legislature both can make law. For example, education is there. Okay, population control is there, family planning is there, criminal law, okay, protection of wildlife and animals, forests, etc. These kind of things require both at the central level a national law, strict national law should be there. For example, in education there is a right to education act. Okay, at the state level, state government schools are also there, no? So both national law and state law is required. On those particular subject, this concurrent list is there. It has 52 items. Originally 47 is there. Okay, from 47 increased to 52. So this particular thing, education is there, no? Okay, and protection of wildlife and wildlife, animals and forests, plants. These particular things are under the 42nd Constitutional Amendment Act in 1976 have been transferred to from state list to this particular concurrent list. Okay, so you may get a doubt, sir, if suppose on a particular subject both parliament has passed a law, state government has passed a law, which will be applicable, sir? Okay, if on a particular subject both state government and parliament passed a law, parliament's law will prevail. Okay, only parliament's law will prevail. State government's law will not be prevail. If only state government is passing a law, then the state government's law will be prevailing. Okay, on a same subject in a same matter. Okay, remember that. So why this particular list system has been introduced? Okay, first there should be transfer of power, decentralization, democratic decentralization. At the lowest level, there should be power. Okay, top down approach is not good. So, due to the diversities of India, okay, so to strengthen the unity and integrity of India, to promote cooperative federalism, okay, to promote cooperation between the center and the states, to promote provincial autonomy. Provincial means states autonomy, to balance the economic development, to have a balanced economic development, to enable responsive governance. Okay, so in order to have better governance, okay, stable economic development, provincial autonomy, cooperative federalism, that's why these particular powers are transferred to the state government. Okay, so we have seen what is this particular list. That is about the 7th schedule. So just go through what are the items present in this particular lists. Okay, different provisions related to that. So if we see, there is a pattern. So all these current affairs topics are directly or indirectly related to this core subject, core topics only. So what you have to do is, you have to read everything in the core subject. For example, for polity, you follow Lakshmikant book. You have to read everything. But whenever you come across anything related to, for example, 7th schedule is there, and that same topic you come across in the Lakshmikant book, you have to give special attention to that. Okay, current affairs are also asked. Most of the questions are asked based on current affairs only. Current events of national and international importance are only asked, but current affairs will be linked with this particular core subjects, core issues. For example, here the news is 15th Finance Commission chairman said something about 7th schedule. It will not be asked in the UPSC exam. Okay, so the issue, the background behind it will be asked. Okay, that way you have to read the current affairs. Then it will be a very easy task. Okay, so you can just go through all the, if you are thorough with the core subjects, if you are thorough with all the standard books, current affairs reading, you can just glance over it, and you can have a glance, and you can cover the entire subject. So if you see, next issue is about borrowing powers of the state government. Okay, to take loans, what is the power of the state government? And state governments can take loans. Okay, what is the constitutional provision? Last year, what happened due to the pandemic? Central government has increased the borrowing limits of the states from 3% of the state's gross domestic product to 5%. Okay, so if 100 units is the state's gross domestic product, GDP is there, no? That is at overall country level. But for each state, there will be state gross domestic product, GDP, state GDP. Okay, or called as GSDP. So if 100 units is there, no, 3% means 3 units. If 100 rupees is the state's GSDP, suppose 3 rupees the state governments can borrow. That limit has been increased to 5%. Okay, that you have to remember. So it's a prelims pointer. Out of 5% increase, okay, states, so 3 to 5 it has been made, no? So out of this particular 3%, additional 1% is there, up to 4%, all the states are eligible, but one more plus one. Okay, this last 1% rise is linked to, sir, what is 3%, 1%? Does it matter? Yes, it matters, because this particular 3%, 2% increase, okay, the states could avail additional borrowing of 1.6 lakh crores. See the figure. That is the tune of increase. So it has very much significance. That 1% increase is linked to the following progress in these particular sectors, the reforms. For example, one nation, one ration card is there, ease of doing business is there, power distribution, okay, urban local body revenues, because the state governments are having many problems, and central government cannot enforce all the schemes, okay, cannot direct, but it has to give some incentives also, no? So the central government has planned this kind of incentive. So central government wants to launch this particular one nation, one ration card. Suppose all the state governments used to maintain different ration cards. For migrant labor, if they are coming from their native state, that particular ration card is not accessible in another state. So they were starving. So in order to remove that particular problem, one nation, one ration card is there. Okay, state governments has to promote businesses, so ease of doing businesses. Power distribution, urban local body revenues, municipal corporation and panchayat revenues will be there. No, they are facing revenue constraints. If the state government gives them revenue, then they will be benefited, right? So that's why these kind of reforms, if the state government has done these particular reforms, then additional 1% will be there. Okay, out of 3% earlier limit, 4% present limit, plus 1, total 5%. If they want to achieve, they have to show reforms in these four sectors. Okay, so overall 23 states out of 28 states, 23 states have availed this additional borrowing of this 1.6 lakh crores. Okay, so if we see, there is a act that is governing this particular borrowing limit, that is Fiscal Responsibility and Budget Management Act. Earlier what used to happen, the central government expenditure will be there, no? Okay, revenue, what the central government is earning will be very much less than what the central government is spending. So there will be a deficit. If you are earning 100 rupees and if you are spending 120 rupees, your deficit will be 20 rupees, right? So how this deficit can be managed? This by taking loans. By taking loans, does the present government, if suppose now BJP took the loan, okay, suppose BJP is out of power in the next election, who has to pay for the loans taken by this particular government? The next government, right? So the burden is shifted to the future. So in order to prevent that and in order to have a responsible budget management, this Fiscal Responsibility and Budget Management FRBM Act was passed in 2003, which sets the targets for the government to reduce its fiscal deficit. To reduce its deficit, there will be certain targets. The Act provides room for deviation from the annual financial deficit target under certain conditions. Okay, there will be targets. For example, here for the state government, 3% target is given. Okay, above that they cannot take loans. But sometimes this target can be deviated. Okay, for example, last year pandemic is there. Using the FRBM Act, there can be or a national security crisis is there, a war with another country. In those particular years only, FRBM Act, from FRBM there can be deviation. Other conditions, in other situations there should not be any deviation. For example, in the FRBM Act, there is a fiscal deficit target of 6.8% of GDP in the financial year 2021-22, right? So there was 6.8% of the deficit when compared to the GDP. So the government target was to reduce this particular deficit to 4.5% of the GDP by 2025-26. Okay, deficit by GDP ratio. How much percentage of deficit is there when compared to GDP? That should be 4.5% limit according to FRBM Act. You have to remember that particular point. Okay, so if we see, to take loans, what is the power of the center? What is the power of the state? Okay, what is the constitutional provision? Is there any article mentioned in the constitution to avail the state governments or central governments to take loans? That is article 292 of the constitution, in which central government has unrestricted power to borrow. Okay, subject to limits set by the parliament. They can borrow anything provided parliament accepts that, but there is no restriction. Under article 92, this power is limited by the state legislature. Okay, for central government borrowing, parliament will set a restriction. For state government borrowing, state legislature will set a restriction. Territorial restriction means from foreign countries or foreign institutions the central government can borrow. Yes, they can borrow. So central government can borrow from abroad. State governments can borrow only from domestic sources. Only within India they can borrow. Any other restrictions are there? No other restrictions for the central government, but state government, they can borrow upon the security of the consolidated fund of the state only. And under Article 293, the state cannot raise the borrowing without the central government's consent if any loans outstanding which is repayable to the central government. Suppose the state government is there. Okay, it has taken a loan from the central government. Already outstanding loan is there. If the state government want to take new loan, it has to take central government's permission. Unless otherwise, it cannot do. Or there is a provision to take provision for the state to take loans from the international market also, provided they have to take the loans on the security of the Consolidated Fund of India. Okay, if states fail, central government has to pay. So the terms and conditions are set up by the central government. Okay, so states borrowing power is limited, central government's borrowing power is unlimited. Remember that. Okay, so FRBM Act, very important. What are these particular reforms asked in the question? You have to remember. Okay, what is the FRBM target? What is the limit, present limit? Borrowing power of the center and the states, you have to remember. Okay, so if you see, some other news articles are there. Okay, so one is special category status. So you have seen, if you are from Andhra Pradesh, you have seen since 2014 there is a struggle, okay, taken up by the state government to get this special category status. Okay, so what is this special category status? It's in news. So what is this particular thing? What is the benefit if the state is having a special category status? If we see, but the state government, Andhra Pradesh is not given this special category status. Instead of that, it is given special assistant measures. Okay, special assistant measures instead of special category status. Okay, so what is the special category status means? So there will be central government, centrally sponsored schemes will be there, no? Central sector schemes will be there. Centrally sponsored schemes will be there. Central sector schemes means whatever schemes are there, whatever policies are there, whatever laws are there, central government will pass certain laws, state government will pass certain laws. Okay, the central government is passing certain laws that comes under the schemes that is coming under the central sector schemes. Only central government has to pay. Okay, if any scheme is passed under the category of centrally sponsored scheme, then what will happen? State governments and central governments has to both state and center has to bear the burden. 50-50 transfer will be there, or 60-40 will be there. 60% expenditure taken up by the central government and 40% by the state government. Like that, depending upon the state concerned, there will be a revenue sharing. Okay, there will be expenditure sharing. So if special category status is given to any state, then what will happen? For the centrally sponsored schemes, central government will bear 90% of the state expenditure, and only 10% has to be taken up by the state governments. And what is the special thing? There will be an external aid given by the central government for the rest of 10% also as a loan with 0% interest rate. Means almost 100% expenditure is borne by the central government only for all the centrally sponsored schemes. Then state government doesn't have to spend anything for the centrally sponsored scheme. So that state government can use that particular revenue for capital expenditure. For example, Andhra Pradesh does not have any capital. In order to develop a capital, it has to have certain amount of revenue. Whatever revenue it is generating, if it is spending on centrally sponsored schemes, then what will happen? It will not have money to focus on capital expenditures. That's why the state government is asking for special category status. The money which is unspent does not lapse, it will be carried forward. Okay, and the state with this special category status are exempted from different things such as custom duties, corporate taxes, income taxes, and other taxes to attract investment. If a company is set up in this particular special category status, that company should not pay any custom duty or corporate tax or income tax, whatever thing. So the companies will try to set up their branches in this particular state, right? So that is the importance of special category status. But for Andhra Pradesh, this special assistant measure, okay, to develop the certain capital infrastructure to create a new capital. Certain amount of money will be there. It will be provided by ways of repayment of loan and the interest for externally aided projects signed and disbursed under the period of 2015-16 to 2019-20. So whatever proposals, okay, for which the state has taken certain amount of loan. For example, to construct a capital, it has to have certain infrastructure, certain companies or certain PSUs, whatever are there, no? Okay, for that, if the state government has taken any loan, then if this special assistant measure is given, using that measure, central government will pay that particular loan. Okay, for externally aided projects. So that is the thing given to the Andhra Pradesh. This special category status first introduced in 1969, okay, and is a classification given by the central government to assist the development of those states which face geographical and socio-economic disadvantages. Only to the states that are having certain geographical or socio-economic disadvantages. For example, northeastern states are there. Okay, you see the northeastern states, they are having geographical factor of not connecting with the mainland India. There will be a small corridor called Siliguri corridor through which connectivity is passing. That's why this region is geographically having certain problems, and there are certain states such as hilly states. Okay, Himachal Pradesh, Ladakh region, those are having hilly areas. So those particular states, in order to hilly terrains or strategic international borders or economic or infrastructure backwardness, non-viable state finances, those particular states will be given this special status. Okay, presently northeastern states are given the special status. Himachal Pradesh area and Uttarakhand is also given the special status. Okay, so the next one is about inner line permit. Okay, so if you see the states which are under inner line permit, you can remember here these bordering states are there. So Arunachal Pradesh is there, Nagaland, Manipur and Mizoram. These 4 states are having inner line permit. What is inner line permit? Suppose from rest of India, anyone has to enter this particular states, they have to take special permission from the state government concerned before entering. To the rest of the places, do you require any permission? No. For inner line permit status, they have to take the permission because these inner line states are having tribal populations. So the tribal people do not want to integrate with the mainland people, right? So the tribal people, they want to protect their customs and their autonomy. So that's why inner line permit is given to protect the communities of the northeastern states. Okay, so why it is in news? Ladakh area is there, no? So Ladakh area has scrapped this inner line permit system. So Indian nationals can visit the protected areas of the Union Territory and boost the rural tourism. In order to allow everyone to enter this Ladakh area, Ladakh administration has simply scrapped this inner line permit systems. But foreigners, if they want to visit to these protected areas, they still need a permit, that is protected area permit, whose validity now extended from 7 days to 15 days. If they take a permit, they can that particular permit's validity 15 days. Okay, this inner line permit is an official document issued by the state government that allows the Indian citizens to travel to the state under this permit for limited period of time. So if you want to travel to these particular places, you have to take this particular ILP document permit for a specific period of time. Then only you can enter this particular state. Okay, so this is based on Bengal Eastern Frontier Regulation Act. Earlier, British has passed this particular act, Bengal Eastern Frontier, this area only, northeastern states. where the British framed regulations restricting the entry and regulating the stay of outsiders in the designated areas. So outsiders cannot enter this particular Bengal eastern area frontier region. Okay, so that region is protected. Now it is converted into inner line permit. Okay, so the next is about formation of a new district. Okay, so how to create a new district? For example, recently Punjab government has created this Maler Kotla district, that is the 23rd district in the state. Okay, so what is the constitutional provision, or how it can be made, how it can be done, by using which law? There is a power to create new district or alter or abolish the existing district rests with the state government. Only state governments can do that. Can be done either through executive order or through a or through a law passed by the state assembly. However, when the state wants to change the name of a district, not the boundary name of a district or a railway station, it requires NOC, no objection certificate, should be taken from the number of ministries such as Ministry of Earth Sciences, Intelligence Bureau, Department of Posts, Ministry of Railways. Okay, because they are having a lot of infrastructure related to, for example, railways is dependent upon the names, right? They have to modify the entire railways, the railway boards and all in that particular area. So NOC certificate has to be taken from these particular ministries in order to change the name. But in order to create a new territory, alter or abolish the existing territory, existing district, can be done by the state government. Okay, but they cannot altogether alter the border of the state. Okay, for example, formation of a new state, constitution empower the union government to create a new state or alter the boundary of a state, name of a state, whatever is there for the overall state, only central government can do that. Okay, so what is the basis of this particular reorganization? It can be based on language or religion or ethnicity or administrative convenience, whatever may be the provision, only central government can do that. Okay, articles that are linked to that is Article 2, 3 and 4. Okay, Parliament is not bound to, if, for example, I've said the procedure, right? So President will be asking the state government, state assembly for its opinion. For example, Andhra Pradesh, Telangana border states have been they have been classified, right, into two states. The combined state of Andhra Pradesh is divided into two states, right? So for that division, there Andhra Pradesh State Legislative Assembly was asked. Okay, so in the Andhra Pradesh State Legislative Assembly, this Kostandhra and Rayalaseema area MPs are having majority. That's why Andhra Pradesh Legislative Assembly, the combined Andhra Pradesh, said that they do not want this particular division. Still, the Parliament has gone ahead with this their decision, and Parliament simply divided this particular state into two states. So Parliament is not bound to accept the views of the state legislature, but President will ask simply for an opinion. Okay, and it does not require a constitutional amendment under Article 368. Only special no requirement of a special majority. If 51% majority is there, simple majority of people present and voting, then the Parliament can simply make a law, pass a law to alter the boundary of a state. Okay, so that is the procedure. So next concept is the sixth schedule. What is the sixth schedule area? Okay, so there will be different schedules of the constitution. In the sixth schedule, okay, it deals with the provisions for administration of tribal areas in the states of Assam, Meghalaya, Tripura and Mizoram. If you see the map, these areas, okay, white portions, Assam, Meghalaya, Tripura and Mizoram. Remember these areas, Assam, Meghalaya, Tripura and Mizoram. These four states are having tribal populations, and generally the tribal people wants to have their autonomy. For example, Naga people are there, Nagaland, they want their own separate country. Okay, Bodoland territories in the Assam area, they want their separate state. Okay, like that, they want autonomy. They are fighting for autonomy. That's why in the northeastern states there is insurgency. Arms conflict is there. So in order to give them special powers, okay, those powers are mentioned in the 6th schedule of the constitution. And there is a 5th schedule also. Except these states, all other states which are having tribal populations, for example Arunachal Pradesh, Nagaland, Manipur, Mizoram, okay, in Jharkhand, Odisha, in some areas of Madhya Pradesh. So in all those areas, some tribal areas are governed in the 5th schedule. They also have powers, and 6th schedule areas are also having powers. The 6th schedule areas have special powers. Okay, so they have autonomy to frame provisions regarding to safeguarding their land, employment, cultural identity, and local population. So they can have their local laws, local customs, okay, enforced in that particular autonomous areas. For example, a new mining corporation has to be set up in that particular area. It has to take this particular permission from the district council. Like that, certain safeguards are provided to the 6th schedule areas. So why it is in news? Recently, MP from the Ladakh is demanding the region to be included in the 6th schedule. Ladakh is also the MP said that, but the provision it may not happen. Okay, so Arunachal Pradesh also has asked for the special category under the 6th schedule. Okay, so only these particular states, Assam, Meghalaya, Tripura, and Mizoram are in the 6th schedule. Okay, the next concept is about appointment of DGP. So why it is mentioned in the central state relations? Because DGP, okay, he is an IPS. IPS will be appointed by UPSC. Okay, but works under state government. So there is a clash between the state governments and the central government. So recently what happened, West Bengal asked the Supreme Court to appoint its own Director General of Police, DGP, without the consent of the UPSC. But Supreme Court refused that particular thing. Okay, but if you see, there is a thing that police is a state subject. Police and public order is a state subject. So whatever laws that can related to the police, that can be made by the state governments only, but except their recruitment, appointment is done by UPSC, which is under the control of central government. So many times if this kind of clashes has emerged, and Supreme Court, whenever clash has emerged, Supreme Court in a landmark judgment, that is Prakash Singh judgment in 2006, has ordered the state needs to send names of the DGP candidates to UPSC, which picks 3 candidates from the eligible names based on the experience, service, and record, and the state governments can select any among the top 3 candidates. Okay, so certain names. So in order to have a mediation, entirely the process, instead of taken up by the UPSC, there is a mediation. Like, so some names will be sent by the state government to the UPSC. For example, 10 names are sent by the state governments to the UPSC. UPSC will select top 3. From the top 3, state governments can select anyone. Now that is going on. Provided the candidate should have minimum 6 months of service left. If that particular candidate is nearing the retirement age, minimum 6 months service should be there. Okay, for that particular candidate, in order to be appointed as a DGP, Director General of Police, for the entire state. In the Prakash Singh and others versus Union of India case, Supreme Court gave 7 directives to put a record on the deep-rooted problems in politicization, lack of accountability mechanism, systemic weakness that has rooted in the poor all-round performance, resulted in the public dissatisfaction in the policing. So if we see policing, there is a public dissatisfaction. Why? There is excessive politicization. There is lack of accountability. There is a systemic weakness. And there is a poor all-round performance in policing in the state. That's why court has given 7 directives can be asked, remember, in the mains question also it can be asked. So what are these particular directives by the Supreme Court? One, there should be a fixed term of 2 years for the DGP once appointed, 2 years he cannot be removed, and 2 years special term for superintendent of police and this SPs also, this station house officer something post is there below the superintendent of police post. So those police officers should also have a 2-year term. There should be a separate investigation and law and order function. So police perform two functions, right? Investigation and maintenance of law and order. So they should be separated. Okay. And to set up a special police establishment board to give special training, and to set up a police complaints authority in the state and district level. So citizens, if they are not satisfied with the police authority's performance, they can go and complain. And there should be a setup of National Security Commission for security intelligence, and at the state level also State Security Commission should be set up. Those are the directives given by the Supreme Court in order to increase the policing efficiency. Okay, so the next article is about next concept is about section 51 of the Disaster Management Act of 2005. So under this particular Disaster Management Act, former Chief Secretary of West Bengal, who will be the Chief Secretary, IAS officer of the West Bengal, has served a show cause notice from the Union Home Ministry under section 51 of the Disaster Management Act, which says that punishment for obstruction or refusal to comply with any direction given on behalf of the central government or state government or national executive committee or state executive committee or district authority under the act. So what happened, certain during this elections, West Bengal elections, okay, Chief Secretary is there, okay, he implemented certain provisions, okay, which were opposed by the Union Home Ministry, but he still carried out those particular things. That's why this show cause notice has been launched. So you have to remember not that particular act, so you have to remember section 51 of the Disaster Management Act, okay, which provides punishment for obstruction or refusal to comply with the direction given by the central government or state government or national executive authority for the public servants. Okay, so there will be a provision of 2 years imprisonment and fine also if there is a refusal to comply with the orders. Okay, so the next article is about district level committees, which are, what are these district level committees? They will be set up by the Ministry of Power. Remember, many ministries have come up with this district level committees, but presently district level committees are set up by the Ministry of Power. Remember, to oversee all power related schemes of the union governments. Different schemes are passed by the union government: Deen Dayal Upadhyaya Gram Jyoti Yojana for rural electrification, integrated power development scheme for incorporating renewable sources of energy, Pradhan Mantri Sahaj Bijli Har Ghar Yojana to provide electricity for all households, that to renewable source of energy, Sahaj Bijli. So these schemes are there, no? In order to oversee these particular schemes, there will be district level committees. Okay, that committee will have an MP of the district as a chairman, other MPs as members, and district collector will also be there. Okay, all the states and union territories have to notify ensuring establishment of this district electricity committees under the Ministry of Power, and this is being done to ensure that involvement and oversight of people. So people are also involved in this particular district level committees, so they can oversee if the power sector reforms are properly implemented or not. Okay, so that is about district level committees. So that's it for today. If you are having any doubts, you can ask me, or else we can end the class here. So let me stop the recording.